Hello viewers, I'm the CEO of PAS Tax Accounting and Business Management Consultants in the GTA region of Ontario. In this video, I'm going to discuss 7 important facts that one must keep in mind before incorporating one's business. So watch this video carefully to the end. The first question that may come into the mind is why to incorporate your business when you can run a business as a sole trader or a partnership without much legal formalities. Well, the one most important factor that persuades people to incorporate their business is the benefit of limited liability. Limited liability simply implies that law considers a corporation as a separate legal entity apart from its owners or shareholders. So the shareholders are not personally liable for the debts of the corporation, except to the extent of the size of each member's shareholding. Instead, the corporation is itself responsible for its debts and liabilities. Suppose the total equity invested by the shareholders in the business is $100,000 and the corporation takes a loan of say $120,000. That is later not paid by the corporation due to losses. Then the shareholders are only liable to the extent of $100,000 invested in the business and not beyond. The corporation will either sell its assets to pay off the loan or it may become a bad debt. Besides limited liability, incorporation may also bring additional benefits to the business in the form of 1. Greater access to credit. 2. Higher business prestige. 3. More opportunities to expand business through acquisitions and going public later. The second question is whether to incorporate as a federal or a provincial corporation in Canada. Well, if you want to operate your business from more than one province of Canada, then a federal corporation may be more suitable for you. This may entail stricter nuance name requirement with the advantage of your company name's protection throughout Canada. Besides, a federal corporation is required to be registered in each of the province from where it conducts its business. So majority of the Canadian controlled private corporations or CCPCs are registered as provincial corporations since the nuance name requirement is less strict and most CCPCs conduct their business from a particular province. The third question is whether to incorporate as a numbered company or as a named company. If you're not brand or name conscious and you want to avoid nuance name fee, then you may prefer a numbered company. In this case, instead of a unique name, a generic name based on a sequentially assigned registration number is allotted. However, most businesses prefer a named company because it gives a unique recognition and brand name loyalty in the long run. The fourth question is, who can be a shareholder in a company? Well, any person can hold shares in a corporation and become a shareholder. In addition to an individual, a person can include a legal entity such as a trust, a mutual fund, or another corporation. The term person also includes a minor who has not attained the age of majority or one who is less than 18 years of age. The fifth question is, who can be a director in a corporation? Well, a director must 1. Be at least 18 years old, so a minor cannot be a director in a corporation. 2. Not have been declared incapable under the laws of a Canadian province or territory or by a court in a jurisdiction outside Canada. 3. Be an individual. A corporation cannot be a director. Remember, a corporation cannot be a director. 4. Not be in bankrupt status. Besides, at least 25% of the directors of a corporation must be resident Canadians. The sixth question is, how many classes of shares be there in a corporation? Well, law is clear on this issue. The articles can allow for one or more classes of shares. There is no limit on the number of classes of shares that can be set out in the articles. If there is more than one class, the rights, privileges, restrictions, and conditions for each class must also be indicated in the articles. If there is only one class of shares, those shares must as a minimum have 1. The right to vote. 2. The right to receive dividends if the board of directors has declared any. 3. The right to receive the remaining property of the corporation after it is dissolved. If there are more than one class of shares, each of the 3 rights must be assigned to at least one class of shares but one class does not need to have all three. Also, each right can be given to more than one class. The seventh question is what the tax implications of incorporation are. We need to keep in mind that a corporation pays income tax on its corporate profits, while a shareholder must pay income tax on the dividend received by him out of those profits. Some people may question that this may be tantamount to double taxation because dividends are paid from after-tax profits of the corporation. Well, there is some truth in it. However, it must be remembered that the shareholders get some tax credits on their dividend income depending upon the fact whether dividend is classified as eligible dividend or non-eligible dividend. I hope you enjoyed this video. Please subscribe and press the bell icon for future updates. Thank you for watching.